I'm back. Oh, where to begin? How about with this? In the summertime, late summer, late August, I got bit by a Staffordshire Bull Terrier. Not my own. It attacked my dog and got such a good grip of my wrist. It bore down and it bore down, and I felt it break as I watched its incisors plunging deep into my flesh and blood squirting out, and was holding it on my bicep, with my bicep, and it was pulling back. The owner was nowhere to be seen. And the police don't want to know. No CCTV, no other witnesses. I have a police complaint process ongoing. I've found the individual. I've told him where he lives. He's known to the police as a bit of a drug dealer, junkie type. He did turn up after all the events and have the gall to tell me to get my dogs off the field. So the Save Julian Assange looks to have failed. What we have here is an order from the Court of Appeal. Now, the British justice system for litigants in person, amateur litigants, people without money, who fending for themselves, it's broken. I still believe, but it's unfortunate that he'll have to spend another 2 years in jail. I don't believe the Supreme Court will allow his extradition to the United States. This is if he survives that long. It would be best all around on the part of the British government and the United States if he met with end in jail. I mean, this is just the whole responses I've got is just nonsense, claiming that there's no basis for any such contention, no matter how long the expression, meaning no basis to the contention that he's arbitrarily detained. This is political facileness, legal facileness, legal stupidity, legal naivety on account of human rights. All the ostensibly what was done was submitted the arguments of the late great Michael Ratner, the arguments which he submitted on behalf of Julian Assange to the UN Working Group on Arbitrary Detention, and to say there's no, they do not touch those arguments with a barge pole. Yeah? They stay away from them, and the naivety that just because he is under let's call it a paperwork arrest and a paperwork detention now is absurdly naive. Not just because I say so, because case law says so. I knew I should have waited longer for my computer to settle down. So given this seeming truth that the law lords, because that's what they are at the Court of Appeal, they're all lords and ladies, I have to brace myself for the fact that my two other cases that lie at the Court of Appeal, that is one in a planning matter and one in an issue with the Magistrates Court and the gas company, will also be rejected because they've been resisted at the lower courts on piddly technicalities. The planning, they are saying that I should have filed it another way. The other way is a pure appeal has to be a pure appeal on grounds of a specific point of law, and that isn't the case that I'm making. The case is a human rights case, and it's a case of then necessarily determining facts, and so the other way is completely inapplicable. The fact that I at first point tried to avoid this High Court litigation and used the more regular early appeal system through the Planning Inspectorate, they also tried to use against me, which to say that it then put me out of time for the original application of grievance, the so-called decision, which is again absurd. If this is the problem with the UK archaic judicial system now, as I see it, is these judges are granted unfettered discretion to adjudge your case in the so-called permission stage. You have it appears, I think, this permission stage essentially serves to whittle out all litigants in person. You have to have a barrister, and a barrister, a QC even, the highest grade of barrister, and then at the Court of Appeal and beyond, it's an etiquette. Regular barristers can't even appear at Court of Appeal and High Court. Yeah, you have to be a QC. Otherwise, you're most insulting of the Court of Appeal and the Supreme Court. At the Supreme Court, late in the most recent cases, we had Lord barristers addressing lords and ladies on the panel of judges. It's all archaic. honorific nonsense. Shut up! So, by now hopefully I'm displaying some pictures of my neighbourhood. I've put wooden flooring to the front of my house, which the council has taken objection to. Now, the planning procedures are quite clear. There has to be a complaint. Planning law isn't like speeding law, where it's all about the scrutiny. Yeah, you was over the speed limit. You are having this censure. Planning law, at least for the domestic cases, is very much not about scrutiny. It's about a complaint, and a reasonable complaint. There's been no complaint about the front of my property. They've just decided to make me their special project, and not least, they've not even seen it finished. They saw it when it was all construction woodwork, or exposed, no surface, just the mesh core yoke that would support the surface finish. And this is a complete, again, arbitrary action by the council, and there's no basis for it. There's no basis in law for this kind of treatment. My gas company, a couple of years ago,
Okay. Would you like to start again? Just,
Yeah. So I'm looking for...
Your name is?
My name is Michael. I would resolve call. This is my ID badge.
Okay.
Okay. And I'm here to speak to Mr. J. Asford.
That's me?
If you can confirm for me the address and postcode here.
No.
No. Research and other visits is recorded for training and monitoring purposes, and I'm here on behalf of the energy provider for this property.
Okay.
Gas and electric.
Mm-hmm. Have you come today by car?
Sorry?
Have you come today by car? Automobile?
Yeah, we're a team here. We are a team here. So,
Where are your other team members?
I have a gas, I have the locksmith here, and the electrician is on his way. Okay. So here's the warrant you've asked me for. This is Teesside Magistrate Court. This is my company who's acting there. Rights of entry warrant, gas operator, 56 Shirley Street, Lee.
Uh-huh.
Okay, granted. It's issued on 7 of 10, 9.
Why wasn't I given notice of this application?
This I cannot really answer. It should have been some letter sent it to you by the gas and electric company and by our company.
Yeah. Well, there wasn't.
Well, in this case then, are you able to make any payment now?
No.
So would you allow us to change the meters to prepaid meters so the balance will be on your hands, dropping slowly?
No.
So you don't disagree with the situation?
That's
now?
right. I'll tell you, that was Teesside Magistrates Court that you showed me, yes?
Yes.
Normally, you would make application at a local magistrates court, yeah?
I'm not sure because I'm not dealing exactly with this.
Well, I am sure because you're obliged to afford me opportunity to turn up.
Well,
Okay, and this is the second time, right? This is number 2 time, and you've not used the magistrates court local here because they probably don't want to deal with it because we've done this before, and I did turn up at Wigan Magistrates Court. Okay?
I don't know.
Of course you don't know. They don't want you to know. Yeah? They want you to get mission accomplished. But you're not going to have mission accomplished today. That warrant, that's totally unlawful of your company, what they've done.
Well, this magistrate courts had the same issue, same warrant issued for different areas, and the police officer there, they were keen to cooperate and enforce this warrant.
Did you attend this magistrates court? Yeah.
No, I did not. There are some colleagues dealing with this.
Yeah. Okay.
Well,
I have information for you that you received no cooperation here.
well, I have to inform you that in this situation I need to ask the police assistance.
For what?
For enforcing the warrant.
Okay.
That's the procedure.
Okay.
Okay. So
For what reason?
But this is the reason. If a magistrate court order is blocked, we can ask the police assistance to enforce that.
On what grounds? This is a private matter. There's no criminal matter here.
Oh, well, I understand, but we need to proceed with this as a warrant. So, police...
This is what kind of warrant is this? To force entry?
No. Application by a gas operator to enter the premises because he cannot do the prepayment meter.
Yeah,
without...
it's a warrant to force entry. It gives you permission to force entry, yeah? What business is it of the police?
Well,
it's a private thing. The police won't come, I'll tell you that now.
Well, I've just informed you. This is what I'm about to do.
Yeah, I'll speak with the police. I'll ask them why they're here, enforcing a private contractual problem. This case is at case is at the Court of Appeal, in fact. Yeah. This case, I have.
I can only tell you that this is.
This is another problem, isn't it? That they send an employee who seems. I don't mean this in a bigoted sense, but I'm not entirely sure you understand the situation here.
The court here understands the situation. If the court would not understand the situation and would have said, well, we disagree with your opinion, would not granted this.
Yes,
okay?
Yes. No. That is your opinion.
No, that is court opinion because they granted access.
I've just told you I have ongoing court appeals. Yeah. What is the truth will be determined at the end of the court process.
Okay.
Yeah. This is just all the time the court makes mistakes, grievous mistakes and errors. Yeah, you've denied me the opportunity you and I mean your company.
We haven't. I'm sure because this is a process that takes about 4 to 6 months to get this work. Okay, so this is why they take into consideration this one because the process is not like we knock one time on your door, we don't find you at home, and we go. Take the warrant. No, it takes a long time.
You don't need to explain it to me because I've been here before.
Okay, then I'll just have to.
Okay, do what you must.
Number from the police and.
Do what you must. Yeah, sure.
Okay, thank you.
Continuing, you've just seen the second attempt. The fact of the matter is, before they can get a warrant, they're supposed to try to fit the prepayment meter with voluntariness. Yeah? Knock on my door, come with a gas man and say, we're here to fit the meter. Yeah? That's the law. No getting round it, and they skip that step. They skipped it last time. Now they've doubly skipped it, because they've not even sent me what they term the human rights letter, which notifies me that they're actually got a date to make a court application. And in any event, they're normally obligated to make the application at a local place to yourself, such that you can attend, given reasonable opportunity to attend. And they've done it to done it at a magistrate's court 100 miles away. So yeah, this is rule of law in the UK. This is abuse of poor people in the UK. This is abuse of vulnerable people in the UK. When I went to court last time, for the 30 warrants that preceded me, they inquired about the vulnerability of those customers and had they checked whether there was any vulnerabilities. Well, there's a big vulnerability here today, and there was last time. I am a vulnerable person who considers suicide all the time, yeah, and is seriously considering it today. Certainly if the police turn up. So my other legal adventures, just to recap, was my mother got a ticket for littering. Okay, now I have the right to ask permission to be heard in court, to have right of audience, or not. I don't have right to the right of audience, but I have the right to ask. This was explained more than clearly, but they refused to acknowledge what I was saying, and they said they had a discretion to refuse me right of audience, which is true, they do, but that isn't what they refused. They refused to even consider it. It wasn't considered under the law as required, that they consider it, that they allow my application, that they consider it and then give a judgment. No, they wouldn't even consider it. That same court case, the procedural law says that they should offer my mother should be asked if she likes to take the stand, not pressured and forced into taking the stand. This didn't happen. These arguably handing out tickets for littering as a criminal offence is not a good thing, period. Right? But if you are inclined to do so, there are human rights protections to protect zealous businesses from persecuting old people and vulnerable people as an easy cash source. Okay? Now those human rights protections prohibit them chasing you onto private property. This wasn't done. The officer chased my mother onto private property. They're not allowed to detain you, but he detained my mother and asked her to come out of the private property while he issued the rest of the report. Yeah, they're not allowed to issue it on private property, but he began his procedures of issuing it on private property and completed off private property. There was several other procedural grievous mistakes. Yeah. My mother my mother is a little hard of hearing as she gets older. She couldn't properly hear him, which is recorded on his camera. She thought, he said, that he caught her with the camera depositing litter, almost, we suspected, following around old people with cigarettes, yeah? But that wasn't the case. He was recording it from the moment of the interaction. She didn't hear that. Now, as audio and video, the procedure laws express that it must be clear that you're being recorded now, and they must explain that. But he is walking ahead of my mother, chatting, and you hear her shout, "Oh, I'm sorry, I can't hear you," yeah, as he's rushing off to get outside the premises. Right? These protections are there to ameliorate the possibility of human rights violations for such a petty thing, which could be solved by education and cultural change rather than the big stick of criminal law. Now, when she got to court, as I've said, she was denied her rights. We put in evidence, yeah, a big bundle of evidence which we wanted to go through, going through this human rights issue and other evidence. She's in the criminal court procedure, she's allowed to put in evidence, and she was given no opportunity to put evidence, right? And the High Court would not hear this case. They wouldn't hear it principally from me about how I was wronged, because I put it in as how they'd wronged me principally, and with the side order of a complaint of gross, a public interest case, that I had witnessed this, right? And they used the technical rebuff of so-called standing. But when it's a public interest issue of such a grave breach in law, in the rule of law, an abusive process, the case law is quite clear that the incentive is supposed to be to get wrongdoing stopped, right? Now, this same plague of High Court judges and lords blinkering themselves from clear public interest cases like the Assange case, that my government is in the business of arbitrary detention, like my planning authority taking it upon itself to tell me to remove all my frontal works, like the electricity company not following the rule of law and the procedures and abusing and getting an unlawful warrant. There are some, like the police ignoring the severity of the injury I've done and making no investigative efforts at all. So yeah, I'm pretty goddamn pissed off at the moment.